good evening, everyone. My name is Jim Santel, and I am delighted and honored on behalf of Blue Sky Waukesha to welcome you to our program this evening. This is the first of 6 classes that we're going to be engaging in during the course of this summer, covering a variety of issues. And as always, we're going to encourage your comments, your questions along the way, and hopefully, I know you will not only learn something, but also be somewhat inspired by what our discussion will be all about. This is the Summer Civics Series. Kristen and the board and I and members of the staff, including Jacob and Gabby and others, have designed this in a way that it not only identifies some continuing civics issues, many of which you probably recall from the 8th grade or maybe the 12th grade or maybe even college, but also in unifying those with current events. And sure enough, I will tell you that even though I did prepare this in general format, a couple of days ago, even during the course of last week, I was mentioning to Debbie and others who are here tonight that this changed even in the past several hours, and that's a good thing. And so you're going to hear at least 3 news stories that illustrate the very points that we're making, civics issues, constitutional law issues, legal issues that you will see from the news, including the thing that's going to start our time together. Before we get to that, let us do just a little bit of analysis here of what the general agenda is. We're going to be spending virtually all of this hour or so, and then the next class talking about basic civil rights, constitutional rights, individual liberties, the kinds of things we think about in connection with the 10 amendments to the Constitution, the Bill of Rights. We're going to focus today a lot on individual rights that you have, and then next time we're going to finish up with those and then talk about the ways in which states and the government in itself interacts with you. Down the road in future classes, we're going to be going back to, let's see if we can get back to the start here. We're going to be going back in the future classes to the other things along the way, the connection again between various participants in our legal system, spending some time about operationally who does what, and then a lot of good discussion, as Kristen mentioned earlier, about the operation of state government, accountability, the media, a whole variety of things. But today, once again, we're going to be spending virtually all of our time talking about the Bill of Rights and individual liberties. Let's get to that right now and begin as a teaser with news that is just breaking this afternoon, very relevant to our discussion. And it's not simply news coming out of Washington, D.C., but it's important for all of us to understand exactly what is going on here. You will see there, that is Stephen Miller. He's one of the deputies, one of the leading advisors to the president at the White House. And I will get to the other fellow there on the slide in just a moment or so. The reason that this became significant to me, and I suspect to you also, even as this was breaking today, is that the news is that in the first few weeks and months of this administration, again, over a year ago, there was inside the White House and perhaps inside the Department of Justice as well, a very serious discussion about suspending the writ of habeas corpus, suspending the writ of habeas corpus. And in particular, it was advanced by Stephen Miller. He also advanced this notion, which we did see come to pass, that the Insurrection Act might also be invoked as a way of ensuring that there could be some law enforcement through the military in control of our cities and our streets. We saw some of that come to life earlier parts of this year. But the big news this day is this serious discussion about the suspension or proposed suspension of the right of habeas corpus. Now, you know, although there are members of our government who do not know what habeas corpus is all about, it is the petition. It's a Latin phrase. It basically means going to a court and asking for release of a body, that is the corpus of habeas corpus, the notion being that there is something about your detention by the government that is illegal, improper, and for that reason, a judge should take a look at that situation and determine that you should no longer be detained. At least that's the request, that's the petition. And why the reason that is so very important in our nation's history is that's the fundamental key behind due process, right? Due process is both notice, being told what it is you have done wrong, allegedly, and second, an opportunity to fight back, to tell the government, to tell a finder of fact that I didn't do this, that the claims against me are inaccurate. That's what habeas corpus is all about. As I'll get to in just a moment or so, it's been suspended only a handful of times, and that's the reason why this is such a dramatic news item coming out of our news outlets just in the recent hours or so. What you have happened here, and the reason why this becomes a part of our national discussion, is a fellow who is on the right there, the lower portion of your screen there. His name is Will Scharf. And all the media says that today that we don't know who he is. He has been plainly inside the White House. He is not White House counsel, but plainly has a huge role to play in his role as White House staff secretary. For what it is worth, and it's important to note, we're not going to be political, of course, during the course of this hour or so or future classes, but he has been in his life a wildly supportive person in favor of not only this president, advocating for the kinds of things that this president has wanted to do. He has, among other things, gone on record saying, for example, that the candidacy of John McCain a number of years ago was not sufficiently conservative. And I make those points not out of political direction, but just to indicate that this is not someone who happens to be embedded in the White House, who is not committed to the fundamental things that the president often says. And that's what makes this story all the more remarkable. And that is, the story is that he has written a lengthy memorandum, and he calls it the writ of habeas corpus. He sends it off to the chief of staff in the White House, and he said, we've got some real problems here. My paraphrase, not his. And he is speaking specifically about what he has heard inside the White House from the mouth and the office of Stephen Miller, saying what we should do is to promote our immigration agenda, we should have the president unilaterally suspend the writ of habeas corpus. We can go and detain people, we can arrest them, we can deport them, and under the writ of habeas corpus, suspending that, there will be no opportunity for those people we detain to go into a court and get relief, to get released through a part of the regular process. Again, a stunning thing to say, and it is significant. This is one of these individuals we've talked about in previous classes, previous years, who is inside government, who is among the guardrails to ensure that the Constitution is supported, and regardless of your political views about any of things that are policy related, someone who is in the end supporting the Constitution. And it is significant to note, and you may be thinking, well, gee, Jim, we're going to talk a lot about the Bill of Rights, and we are going to do that. But if you, and I had to look back at myself to confirm this, the writ of habeas corpus is actually not in the Bill of Rights. It is in the core of the Constitution. In particular, you can see that's Article 1, which establishes the legislature. Section 9, it's all the listings of the things that the Congress can and should do. And in particular, Section 9 says the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, when the public safety may require it. And so again, those two fundamental notions, when there's rebellion or in a situation where there's an invasion of our nation. And both of those things interpreted over time, again, in the core of the Constitution to mean just that. Your traditional notions of a rebellion, an attempt to overthrow the government, or an invasion by a foreign power. And that's it. And it also, again, is significant that it appears in the Constitution among the responsibilities of the Congress to do. And so this fellow, again, inside the White House, Will Scharf, he writes this memorandum and says to the chief of staff, we need to stop this idea for both reasons. Number one, the president does not have the power to suspend the writ of habeas corpus, can't do that constitutionally. And second, it's a very bad idea because we're not in a state of rebellion and we have not been invaded. And it is significant, of course, that in the end, at least as to this, the decision was made probably because of people like him still inside the government saying, no, we can't do this. That plainly did not happen. This is reporting that goes back a year. This is discussions that were happening inside the White House at that time. And I raise it not only as a teaser to our discussion, but to underscore the ways in which these fundamental rights that we assume are going to be in place and remain in place throughout the future of our nation, in fact, they can be threatened. And even the discussion about this should be a source of concern, as it is to an awful lot of people. What the author of the memoranda writes is just this. He says, the history of habeas corpus dates back to the very dawn of English common law. Denial of habeas corpus rights, that is, not giving the opportunity to be told what you're charged with and to appear in front of some magistrate of some kind to defend against that, was a key grievance underlying the American Revolution against the king. And the right to apply to the federal courts for habeas review dates to the beginning of the Republic. He goes on to talk about throughout U.S. history, all three branches of government were loath to interfere with habeas corpus, and so he writes, doing so only in the direst of circumstances and typically with respect to the very limited categories of individuals. And for what it's worth, you probably will know this and recall this from your own history, suspended only 4 times, most recently after Pearl Harbor. In every case, the country was at war, armed rebellion, Civil War. At the start of the Civil War, Abraham Lincoln did do this, claiming he does have the power to do it, and the current president apparently invoked Abraham Lincoln in support of this notion, well, gee, I should be able to do this too. Scharf also cited President George W. Bush, claiming the executive power to indefinitely imprison terrorist suspects at Guantanamo Bay, and maintaining that no court had the ability to look at those folks and say, we need to determine whether or not the government is detaining them properly. We know in the end, again, another time, way back in 2008, the Supreme Court specifically told President Bush at the time, you can't simply do this. You've got to afford them due process. And so it makes today's story all the more interesting and compelling, and it's also the start, if you will, of our discussion about these fundamental things in our Constitution that animate us on a regular basis. And so let us talk about a little bit, and you know well that we could spend several hours talking about the Bill of Rights and where it comes from. These are the kinds of things that I find interesting. I suspect you do as well. And I thought that just by way of introduction of some of the people, again, who are responsible for this, and some of the stories about the creation of the Bill of Rights, we assume, of course, that it's always been there. It was there shortly after the start of our nation in the first Congress. But the reality is that this was a source of great controversy. And you can see 2 people up there. The fellow on the right there, his name is James Madison. All of you know he was also the 4th president of the United States of America. He is generally regarded as the author of the Constitution of the United States. Now, he didn't do it alone, we know that, but when people speak about particular phrases in the Constitution, they often attribute those to James Madison. And he put together, again, the core of the Constitution before any amendments were attached to it. And so when the states ratified the Constitution, there was not a Bill of Rights attached to it, and that was a source of great controversy. Among others, people like George Mason. He was from Virginia. He was a very, very wealthy man. He was a planter, a farmer. And he, among other people, said, I support the core of the Constitution that you have authored, Mr. Madison, but I'm going to go back to Virginia, and I'm going to advocate that they not ratify the Constitution. Why? Because it doesn't have the Bill of Rights, these fundamental things that we assume are core to our understanding about America. And indeed, it was not only George Mason, but other people who were looking at this document, just created, and again, created with an awful lot of compromise, right? A lot of the history suggests that not that they were exhausted after this, but we think about the great compromise that got the Constitution in place, basically codifying at this time of our nation's beginning the notion that slavery is a portion of our history, many, many other things that were sources of great controversy. And as a result of that and all the back and forth, the arguments at the time, the decision was made to go ahead with the Constitution without a Bill of Rights, prompting an awful lot of people, including George Mason, other folks in other places around the nation, to the emerging nation, to say, we're going back and we're going to fight against this thing. We're going to keep it from happening until there is a Bill of Rights. And there was eventually sort of a rapprochement, so to speak, between all these folks. And the promise that Madison made to the people like George Mason and others was, If you ratify this, if you go to those states, including Virginia and Massachusetts and New York, if you put this thing in place, we promise that in the first Congress, the very first Congress, we're coming up on the 120th Congress next term, the very first Congress, the very first bill, the Judiciary Act of 1789, that will be a presentation to the Congress to amend the Constitution to include a Bill of Rights. And so it wasn't there from the start, and they agreed. They shook their hands on this, apparently, and said, all right, we're going to trust you, James Madison, to go ahead. And indeed, that was the history. And there's a whole lot more of history related to that. And it's just significant to note that it was not just not a part of the original Constitution, but was the product, again, of an awful lot of politics. The reason in part, not the principal reason, the reason in part that it was incorporated into our Constitution as a first act of the Congress was to ensure that the entire number of states voted to support the Constitution itself. The other reasons you can see up there plainly, this notion of protecting individuals, that's what we think about when we think about the Bill of Rights, individual rights and liberties, and also, again, to preserve, as we'll talk about in a future class, the separation between a federal government and a state government. What is the relationship between those? What does the 10th Amendment say about all of that? And how do the states work in this newly formed government that we have not seen before? Again, you know well, in the wake of the Articles of Incorporation, which was not successful, this very loose tie among the states, this was an attempt to bring everybody together. Huge questions about the ways in which the states would continue to act, what are their powers, while the federal government, the huge and seemingly very powerful federal government, proceeds apace. Here's the other footnote to this, and then we'll move on to some specifics to illustrate all of this. And again, I think that this is an interesting part of this, is that initially, when James Madison wrote this, he came up with 20, count them, 20 amendments. And all sorts of things, some of which eventually become a part of our national history. Eventually what happens is that the House of Representatives, they say, James, that's too much, we're going to cut it down to 17, goes over to the United States Senate, and they come up with 12. So again, a legislative system from the very start. And it is also significant to note that the 12 amendments, again, those are the ones that are then sent on to the states for their ratification. And you're probably thinking, well, wait a minute, the Bill of Rights, those are 10 amendments. What happened to 13 or 11 and 12? The answer is, I've already misnumbered them, because the ones that fell off were actually numbers 1 and 2. Number 1, authored by James Madison, was all about counting the population and trying to somehow attach it to the population of our nation in 1789. A bit more complicated than that, and he proposed that. It was among the 12, it goes to the states, and the necessary number of states have never, ever ratified what really was Madison's very first amendment. Then there's a part of this that's, I think, even more fascinating. That is his second amendment, before we get to the others, is basically about compensation for members of Congress. And I had to look at this again, wouldn't expect that most Americans know all about this. It was proposed at the time of James Madison, and you talk about how long it takes government to do things. Turns out that 203 years after James Madison proposed that, the United States of America embraced that. It is the 27th Amendment to the Constitution. And so that's one which never was passed, two which gets passed over 200 years later, and then actually our present Bill of Rights, numbers 3 through 13, that then becomes the first 10 amendments to the Constitution. There's your history lesson for today. I find that fascinating. I suspect you do too. An awful lot of machinations going forward on all of that. So let's talk about what becomes the First Amendment to the Constitution. We're going to spend most of our time chatting about that tonight. We're going to talk a lot about some of those basic fundamental notions there, the right to petition government, which is there, the right, obviously, to assemble peaceably. That's protesting, that's advocating in your communities and in other environments. We're going to talk tonight a little bit about, more than a little bit about, again, much related, the right to freedom of speech, much entwined with the right to protest, to be out there and advocating to your government. And then we're going to do just a little bit inside that about students' rights And finally, we're going to chat a little bit about the press tonight. So we've got a lot of ground to cover, but I think we can do it. That, of course, is the First Amendment. I suspect, as you do, if James Madison were here today, was either a lawyer or someone who is a part of government today, that would probably be 15 pages long, right, as opposed to what it is. And some of the beauties of what Madison wrote initially is because it is so skeletal. It's so simple. What that means, however, is that for the past 200 years, we have been looking at that and trying to figure out what that language means. And the Supreme Court spends a lot of time, we're going to talk about some of those cases tonight, interpreting that very basic language and trying to figure out not only what James Madison and George Mason and others meant, but what it should mean today. And this is the first time you'll hear me say this in these classes, but this notion which I would advocate for, and without being partisan at all, I think that most people who understand where we are today would advocate for a living constitution. And the reality is, as I've often said, that James Madison and George Mason, these other folks, even when they wrote these words, they could not have envisioned a press, a media of the sort that we have today, right? They could not possibly have envisioned, frankly, any of the things that we think about in our daily lives. And so this notion that somehow we need to go back and determine what James Madison actually intended at the time of the first Congress, and that would be the directive when it comes to interpreting this, cannot be the way that we go forward. There are those people out there, they're called textualists, they're called originalists. There are all sorts of things out there that justify on a theoretical basis doing that. A living constitution is what we necessarily have to have. And there is your First Amendment that, again, living today still in 2026. So let's talk a little bit about some of the basics here. And I'm going to do a little bit of law school. You do not have to write all this down, nor do you have to appreciate all this. But just note along the way that, again, the Supreme Court has again, as late as 1876 into the 19th century, even the 20th century, still interpreting what the First Amendment means when it comes to your right to assemble, your right to be out there, to assemble even this evening in this room to gather together to talk about things. There's a major case called Cruikshank. You see it there. And surprisingly, the Supreme Court had to articulate to the nation that, yes, indeed, the First Amendment does give the population the right to assemble and to protest and to go to government and ask for changes. They had to acknowledge at that time that the peaceable public gatherings cannot simply be suppressed by government because the government doesn't like that to happen. That was a notion that wasn't articulated until 1876 in Cruikshank. There's another case, again, the Hague case, that said the same thing. Basically, city officials claiming that they've got absolute rights, absolute discretion, because they're elected, because they're appointed, they can make decisions about who can protest and who can't. The Supreme Court had to say, no, you can't do that. And then they went on to define, as we will see, all sorts of principles that guide that and give that some meat. And among those, which you will see in some of the other cases coming up here, the restrictions that government can impose upon your right to assemble, the right to speak, the right to protest, basic First Amendment rights, those include, you'll hear me say this a number of times, time, place, and manner restrictions. I've often said this in the past. There is no right in the Constitution, including what we now know as the first 10 amendments to the Constitution, that is inviolate and unconditional. Tell me the right, give me the right, and I can tell you how it's limited. And that includes the First Amendment. You cannot simply, under all circumstances, say whatever you want, whenever you want, however you want. And you know that to be the case. There are limitations even on that, but it underscores the notion that, again, no right that is unconditional out there, and it has got to be applied by government when it comes to restrictions and limitations. Government has to do these things in a neutral way, without specific kinds of focuses on the substance of what you say. Can't be content-based. In other words, if government makes decisions about who, in fact, will get a permit, who will be permitted to go out there and protest, it cannot be based upon the notion that I don't like what it is you are saying, right? Time is different. I can prevent you from doing it on my front lawn at 3 o'clock in the morning, for example. I can prevent you from coming onto my lawn, perhaps, because that's a place restriction. and of course the manner in which you communicate that. All of those things in common sense with some balance can be regulated, but content itself, with some limited exceptions, cannot be regulated. That's what comes out of these cases coming from the Supreme Court. And so we've got a whole bunch of other cases. You can take a look at those. The upshot of all of them is that under the First Amendment, again, as James Madison anticipated, we will permit you to say an awful lot of things in our public discourse that may be offensive and that people may not agree with. We will let you do a certain amount of name-calling, candidly, as long as it's not enticement or incitement to injury or danger. You see that up there, this case called Brandenburg versus Ohio, another major Supreme Court case, as late as 1969, that said that speech can in fact be prohibited if you are causing or inciting violence. And I know what you're all thinking, which is references to January 6th, and that was in part one of the reasons why a grand jury indicted a person who was soon to be private and is now our current president for violating the incitement test, right? So that's one of the limitations on the First Amendment. But note overall that all of these cases, again, give great breadth and great span of liberty when it comes to First Amendment rights. We will let you say things that people do not, that people will not agree with, that others may find offensive, and that's a part of our history as well. The focus there also on students' rights, those kinds of things that we'll chat about in just a few moments. All of this to underscore basic balance. Kristen, thank you so very much. Appreciate that. Good. And so let's get into a few more of these and specifically talk about some applications of what James Madison put in place, not only way back in the first Congress, but also since then. These time, place, and manner restrictions allow government officials, under appropriate circumstances, to regulate your capacity to speak out there, specifically in public domains. And again, the only limitations on that has got to be content neutral, as I've said already. Can't be making a decision to restrict you, to prevent you from being out there because of the topic, the subject, and the way or the content of what you're saying. You can think about all kinds of controversial things that are out there. As long as they are not incitement to danger or injury, we will let you say those things, and that's what America is all about, right? And beyond that, any limitations have got to be fairly narrowly tailored to the specific circumstances. And so it may well be that I will permit you to articulate things in a public park, in other places in a public domain, but I'm not going to let you do it, for example, on an expressway, right? Or some other place that would cause danger to many people. And it's got to be tailored to circumstances where that public advocacy is appropriate. And much related to that is number 3 there. You got to be able to provide some alternative options. If we tell you, you know what, you cannot do it here in this particular venue for various reasons, perhaps there's some other place where we can permit you to do that. And that, again, that's all a part of the process here by which government should be supporting your right under the First Amendment to articulate, to speak, to protest, to advocate with those certain limitations. And so, again, a couple more cases here. We often think about permits. And indeed, look at that. 1941, again, 1989, the Supreme Court saying that in that connection, this balancing between your sacrosanct right to be out there to speak in ways that you feel strongly about, the government can also require, under time, place, and manner restrictions, can require that you get a permit. And the reason for that, again, is because we live in a society, and you want to make certain that when you do that, if we give you permission even to go into a park, that you are doing that in a way that we can provide for your safety and security, that of other people. And a permit permits us to understand what you're doing and enables us to ensure, for example, that the police may be there, to ensure everyone's safety, to ensure that others may not be there who will otherwise undermine your right to speak. And so one of the things that can be done is the regulation of public venues through a permit process. The upshot is that is constitutional.
difficult to say that if you decide to advocate in a public domain on a sidewalk in another place that's fairly public, that you need always to get a permit. But certainly when it gets to a certain stage, you've got hundreds of people gathering, as we've seen recently in America. Those are circumstances where, yeah, probably a local community can say, we'll permit you to do this, we'll support you in your advocacy and whatever you're doing. Fill out the form and get it in place so that we know what's going on here. And again, just some real basic fundamental notions. This is my role somewhat as a legal advisor. And you understand, again, that I spent most of my career working to ensure these kinds of things are upheld, but also that the criminal justice system is wedded into this in a way that does not trample on your rights to speak publicly. So again, where are those circumstances? Where are the places where your right to speak publicly are most strong? I've already mentioned one or two of them. In parks out there, places that are designed by the community to ensure that people can gather together. Streets, sidewalks, those kinds of things. And even there can be limitations depending upon how big the street, the sidewalk may be. You get a permit? Yeah, indeed. The government may let you close down a street and have your protest in an area that otherwise would not permit that. And again, public plazas, common areas, even outside a government building. Here in Waukesha, places of government operation, you can go to those spots if they in fact have common areas outside, and you can protest there. Again, typically you may want to get a permit, but those kinds of places, especially since when it comes to this notion under the First Amendment of advocating, petitioning your government for redress of grievances, as James Madison wrote, what better place to do it than in front of a government building? Supreme Court has said, yes, we recognize you may want to be there, and we'll let you do that, but again, depending upon the physicality of it, the geography of that may be affected somewhat. You cannot obstruct, obviously, the course of people coming in and out of those buildings. Can't do things purposely to prevent them from going into those government buildings. You can't stop the operation of government, but there should be some balancing so that you're there and you can be heard and be articulate in your advocacy. Depending upon the size and location, again, permits are probably a wise idea. And here's the other one that we were often asked recently in connection with many of the things going on in America. What about photography? And specifically these things that we all now carry around in our pockets, these things called cell phones. The answer is, if it's in the public domain and you are watching it, there is a presumption that if you've shown up at one of these public gatherings and you're a part of the group, or frankly, even if you're just there to watch, you do not have the kind of privacy right that you would have if you stayed at home, right behind your doors, or even on your own property. If you're going to a public park and you know that there is a group of people who are protesting there, you have to assume that you're going to give up a little bit of your privacy, and that means your physical imagery as well. What that means practically is, yes, indeed, if you are there, you can take pictures, and you can take pictures of other people. They may ask you politely not to take their picture, and you can decide whether to grant that request or not. You can take pictures of law enforcement, of people who are otherwise from government who are doing these kinds of things. Again, why? Because the First Amendment permits you to do that. A technology, plainly, that James Madison never could have contemplated, but now we do that. We've got a question about the fourth row back. Right. So the question is, what about the presence of law enforcement, say, for example, across the street making an arrest? And there, once again, as you've described in your good question, if the police officer is at the front door going in either on a search warrant or an arrest warrant, doing that sort of thing, at the front stoop, that's public domain stuff, right? That's a situation where you can see that visibly. Once you go inside, plainly, you do not have the right, to follow that law enforcement officer in and take pictures there. But yes, indeed, if in fact law enforcement is doing something not specifically a part of the protest that I think you're talking about,
you can take pictures of that as well. It's in the public domain. The assumption is that law enforcement and other people are doing that in a way that permits that kind of public visibility. And again, in the wake of all this litigation about the dimensions of that, that's the common understanding. Was that your question about? Very good. And so let's follow up on that very good question and talk about specific engagements with law enforcement. Again, this is kind of your practical primer on what you can and cannot or should. Some of this is just recommendations from me. And it has to do with the circumstances under which you go beyond just photographing. Police come up to you and they're chatting with you. That is up to you. You can certainly engage them in friendly banter, or you can choose not to do that. And the question is whether or not you are being detained, whether you are in custody. And again, if this were a law school, we'd spend weeks and weeks talking about what custodial situations mean, what detention means. But the upshot is basically that police can't arrest you. They should not be detaining you unless they've got some reasonable suspicion to believe that you are committing a crime. Now, that could be something like disrupting the public safety and security, causing harm to somebody else, property damage, all kinds of things. But it has always been, footnote, until last summer, that the standard, the thing that I taught for many, many years to law enforcement was when you're out there on the street, you're in Waukesha, other places throughout the state of Wisconsin, when you do that, when you are there, the police have got to have some reason to arrest you. Again, the standard is some reasonable suspicion. Is it probable cause? No. Is it proof beyond a reasonable doubt? No. Those are much higher standards. But the officer cannot simply say, you know what, Jim Santel, I don't like the color of your suit. I don't like, frankly, the thing that you are saying. There's got to be some reasonable, again, a balanced assessment of what the officer is thinking. And there's got to be what we call a suspicion. It doesn't have to be proof yet, but something about your conduct. You may be engaging in some even behaviors that suggest that you're hiding something. Maybe you've got a gun of some kind. All kinds of suspicious behaviors might be in the kind of the taking in from the police officer that could prompt detention. It's a very low level, but it cannot simply be, I don't like what's going on. I don't like your advocacy, I don't like the subject matter, and I want to take you away, okay? I mentioned just a few moments ago that that was the standard, and that's what I taught for 30 years to law enforcement, federal, state, and local. You may recall that coming out of the Los Angeles experience of last July and August, like Chicago, like Portland, other places around the nation, including Minneapolis, a huge focus on detention by ICE agents, by Border Patrol agents, even by other federal agents. And the question was, are detentions being made, are arrests being made without a reasonable suspicion? Now, if you've got a basis to believe that this particular person is in fact deportable, there's a deportation order, you may have that basis to do it. But once again, you can't simply go up to somebody and detain them. Why? Because you don't like the color of their skin, or you don't like the place that they happen to be hanging out. They don't like the job opportunities. And so what happened was that there was a judge named Mame Frimpong. She is a district court judge in Los Angeles, and she had in front of her circumstances. She had a hearing on this. She had testimony about officers, federal officers in Los Angeles, making arrests of principally Hispanic, Latino residents of the community based on precisely those kinds of things. Their race, the fact that they're convening in a place where day laborers are often employed, the locations where they're happen to be congregating, nothing to suspect, no reasonable suspicion that they're engaging in crime other than the fact that they are there and they have an image that law enforcement may not particularly care for. And she said, you can't do that. That's not America. You've got to have some reason to believe that every single person you detain does in fact, or has in fact, engaged in some kind of criminal conduct. And so she reaffirmed that, and we all said, okay, that's a good thing. Went up ultimately to the Supreme Court. A petition by the Department of Justice went to the Supreme Court, and the Supreme Court, curiously, to this day, overruled that proposition. And I remember thinking at the time,
What does that mean then? If we no longer have reasonable suspicion, what is the standard? And Brett Kavanaugh, one of the Associate Justices of the Supreme Court, was one of the people, again, this was one of those emergency applications. He probably recognized that there will be an awful lot of questions about what this means when it comes to your right to be out on the streets and, again, advocating or simply be present on the streets. And he wrote, one of the few times that a Supreme Court justice, in the context of these emergency applications, wrote several pages on it. And he said basically this, which, again, I'm going to say out loud. I believe that it is a stunning rescission of our understanding of what law enforcement does. He said, you know what? Any one of those things individually is not a basis. That's right. There's no reasonable suspicion the person is created or engaged in crime simply because of the color of their skin, the fact that they may be a day laborer at a particular location, that they may in fact be in an area where there has been a lot of crime, those kinds of things that do not lead you to believe that that person is engaged in crime. Any one of those individually is not sufficient to arrest. But he said, hold on, that if you bring them all together, if you put them all together in one pot, then you probably do have enough. And so in other words, a 0 and a 0 and a 0 and a 0 makes a 10. And then he went on to say this, that, well, in Los Angeles and other places, for example, we know statistically who the government has been arresting here. If among, say, 100 people that you arrest, again, without reasonable suspicion to believe that they have engaged in criminal conduct, and it turns out in the end that of those 100 people, 10 of them are indeed or have indeed engaged in some crime, maybe 10 of them are in fact facing deportation, 10 of 100, statistically, that will also be sufficient for you to arrest 100 people because your yield will still be 10 people. That is a stunning, stunning statement coming from any judge in America, and you should know that that rescission of that principle is often referred to as a Kavanaugh stop or a Kavanaugh detention because it just upends our fundamental understanding. I tell you all about that because it is relevant to First Amendment. And if we were getting together a year or so ago, which we did, I would say this to you unequivocally. Today, because of what the Supreme Court did just last summer, it is much less clear that this reasonable suspicion standard is out there. You should still, and my advocacy to you is still maintain that you cannot arrest me, officer, unless you've got a reasonable suspicion to believe that I've engaged in some crime. My advocacy in a public domain is not criminal. I can do that. James Madison told me I could. And for that reason, you can in fact talk to a police officer who may be detaining you and ask that officer why it is that you're taking me into custody. That is a legitimate question to ask. If you're taken into custody, what you should do, if you've got a friend along, record that, whatever the officer says, make note of that because it's going to be relevant at some point down the road when perhaps someone like you contests your arrest based upon the fact that reasonable suspicion is not there. So my own view about the America that we all still love and endorse is that the reasonable suspicion test for protests out there has still got to be in place. And I'm hopeful that law enforcement is still being told, contrary to what Justice Kavanaugh said, that just because you've got a statistical likelihood of arresting lots of people, or just because you've got all these individual pieces that together do not form reasonable suspicion, that should not be, cannot be the test in America. And beyond that, again, just some notes there. If the officer, again, does not give you a sense of the reason for your arrest, you can simply indicate that I'm walking away. The question is whether or not you are in custody. If the officer tells you something else, then you should note that and obviously behave accordingly. And the other part of this, just a small piece of criminal procedure here, not that you're going to be arrested, but again, it's relevant to First Amendment rights and the things we're talking about here. And it goes back to Miranda rights. You all know what those are, and it's often viewed by people that if you're not given your Miranda rights by law enforcement, that the entire arrest is invalid. That's not what Miranda says. Miranda says that in order for the government to be able to use any statements that you might make after your detention, after your arrest, again, you've got a complete, as you know under Miranda, a complete option and opportunity not to make any statements. We all know what Miranda is. You can all recite them because you've known about them since the 8th grade. You see them on television all the time. You have a right to remain silent, right? If you choose to give up that right, anything you say can and will be used against you, right? That's that fundamental concept. If you you have a right to counsel. If you can't afford a lawyer, we will appoint one for you. All those things that you know off the top of your head, that's the Miranda rights. If they're not given to you, it doesn't mean that you have to be released. It simply means that any statements that you have made after the failure of government to tell you what Miranda rights are, those cannot be used. That's your evidentiary lesson for this evening as well. So all those things related to First Amendment rights, protesting out there as we talk about them this evening. So, much related to that, again, I've been talking a lot about the physicality of the geography, time, place, circumstances, manner of restrictions on public coming together. But again, this fundamental notion that at the top of the list should be a presumption by government that you have a right to speak and you have a right to do it publicly. The much related portion of the First Amendment, of course, speaks about the freedom of speech, right? Freedom of expression. And again, we could spend an awful lot of time talking about that as well. Here, I simply want to note the second instance just this evening from just last Friday, an issue where a judge here has made a determination, what is basically a First Amendment right. And you probably know about this. This particular decision that she made on Friday fell under a lot of the headlines because so many other things were going on, including what some people believe to be another First Amendment case involving the name of our president on a certain theatrical building in Washington, D.C. May or may not actually be a First Amendment right, but this was happening at the same time that that one was going ahead, and I've offered to you that it underscores the point that these issues about the First Amendment are still very much being decided in 2026, and they're on the lips and from the voices of judges and advocates on a regular basis. What happens here? Again, you probably have seen this from past reporting. You know that when the president first came into office, and since that time, he has routinely been telling the National Park Service, they're a part of the Department of the Interior, that he would like various materials to be taken down. And during the course of some of the directives that he has issued, he has called for removing or covering up materials at national parks, according to the White House, that inappropriately disparage Americans or cast the United States in a negative light. Now, even as I say that out loud, you understand that that's completely contrary to what James Madison and what we've been talking about up to this point. We will permit you to say things that are about our nation, that are negative in nature. That's what the First Amendment is all about. And indeed, going just beyond that, it is a part of our country that we should learn from our past mistakes and we should do better in the future. But the president, again, early on, this directive, one of his executive orders says, I want all these things taken down. So, for example, as you see there, he didn't want any further references to slavery at the Philadelphia location there, Independence Hall. He wanted a reference to climate change at Fort Sumter in South Carolina. That was taken down. Indigenous people references at the Acadia National Park in Maine. All kinds of things around the nation that the president and the Department of the Interior chiseled them off of various buildings and other places. And so what happens is there's a challenge to that. And you might think, well, gee, isn't that just basic education? And it is. But it's also, as the judge cast it just last week, it's a First Amendment issue, right? It's a notion that we should be able to talk about these things, that whether it's the government posting some things about what our history has been all about, or the possibility that you can come there with your families and your friends and you can talk about those things in a public domain. It's exactly what we think about when it comes to your First Amendment rights. And so I want you to meet District Judge Angel Kelly. She is in Massachusetts, which of course is where Independence Hall is. And she is confronted with this litigation, people challenging this. And Judge Kelly, in the end, a 63-page ruling. And no, I'm not going to ask that Kristen make copies of that and distribute them tonight. Maybe that'll be in the future, or right, or read it, as Kristen has just said. But the reality is that She spends a lot of time talking again about the history of the First Amendment last week, and talked about all these things: time, place, and circumstances, manner of expression in America, all the things we've chatted about right now. The fact that, yes, permits are appropriate, and that the whole reason for our discussing things in the public domain is for education purposes, knowledge about our nation. And so she begins her 63-page ruling by listing examples of national parks. What she talks about is educating visitors about, as she says, difficult periods of American history. And then beyond that, the contributions made by people of color, gay and transgender figures, women, and other minority groups. She talks about all of that huge amount of history in this First Amendment opinion of just last week. And then she says this: from the echoes of abolition in John Brown's fort in Harper's Ferry to the genesis of the modern LGBTQ civil rights movement at the Stonewall National Monument, to the retreating ice of Glacier National Park in Alaska, the national parks preserve the multifaceted and multi-layered history of our nation, including the good, the bad, and the ugly. And the lawsuit, the petitioners here, they were arguing exactly for that. She's saying that the removal of these materials is arbitrary and capricious. That's kind of the legal standard that says you've done it without basis, in violation of also not only the First Amendment, but also a thing called the Administrative Procedures Act. We've seen a lot of that recently. That is the legislative provision that says before you can do things like change structures in Washington, D.C., you've got to have a period of comment by people talking about whether this is a good thing or not. The APA says there's a process for doing this. You can't just go out and do it, right? And they also accuse the Park Service through the presidency of exceeding its legal authority. This notion, once again, the good, the bad, and the ugly, that's Judge Kelly just last week making this so very timely tonight as we gather together, saying that we're not going to restrict your comments, your observations, the things that you say, even that you write about, just because somebody else might disagree with them, and that they may be uncomfortable. They may be true as well, right? They may have that additional aspect to them. We're not going to limit it based upon content. That, once again, is the content-neutral notion that I talked about before. And again, an awful lot of thought that perhaps, as the administration is doing a lot these days, this may well be appealed. But it struck me as I was preparing for our time together tonight, here's an example of the courts today enforcing your First Amendment rights under the Constitution of the United States of America. Judge Kelly, I did not know her before. I've never practiced in front of her, but plainly somebody who's got it right. And I suspect that James Madison, even not understanding all these things, obviously wouldn't know about Fort Sumter, would not know about other things around our nation, including LGBTQIA histories. Nonetheless, he would embrace exactly what she has said. And then we want to spend a little time, as I promised, talking about a specific subset, also under the First Amendment, that again I find fascinating. I suspect you do too. And that is, what are the impact of First Amendment principles, all these things we've talked about, on students? What about an educational setting? I know right here in Waukesha and other places around the nation, this has been the focus of a lot of debate. What kinds of restrictions can be placed upon students in an educational setting? And I am very quick to note that we're talking here about public education. In a private setting, private schools, a whole lot more liberties to restrict opportunities to speak and to be out there. But in the public schools, what are the pressure points? What has the Supreme Court said about the capacity of students, including grade school students and high school students in particular, to advocate inside the school environment? Do they have the same kinds of rights that you would have, for example, as adults out there in the public domain? And this is this great language that comes from a case we're going to discuss in just a moment or so. And you see it there. Students and teachers, this is from the United States Supreme Court, do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Just because you come into a public venue where teaching is going on does not mean that you surrender your rights. There are limitations, plainly, that may not attend for adults and others in the public domain, but you're not surrendering them completely. And that language, if you will, the reason why it's so bold on that particular slide is that has become iconic when it comes to First Amendment rights in America, and especially cited by an awful lot of people, rightly out there, who maintain in the student and teaching setting that their rights are being infringed to speak out, to advocate, to assemble, to put together groups, and to be advocates inside their institutions. The restriction, of course, and again, there's always a condition on this, is whether or not the speech or the conduct will cause what's called substantial material disruption of the educational environment. And I know you're all going to say, well, gee, Jim, what does that mean? And the answer is, of course, it depends, right, on the particular circumstances and the environment in which you're found. The reason why that's even described there with those adjectives, it's got to be big. It's got to be substantial. It can't be just a small-time infringement on students' right to speak out in a public setting. It's got to be material. It's got to be something that's significant, changing the very fabric, the very atmosphere of education. And it's really got to be able to stand up and say, you know what? This is disrupting affirmatively what we are trying to do. Again, going back to the fundamental principle, we let students do an awful lot of things. Those of you who are educators know this much better than I do. Because of the First Amendment, we'll let them do some things that we may not be perfectly consistent with our operation, but we let them do that. Why? For two reasons. One is the First Amendment says that they have that right. And second, what a great educational way of showing them what America is all about. And so that leads that case, this particular language, we get to this then young woman. She is now an adult, and she from time to time gives interviews about her own conduct. This is the major case involving First Amendment rights of students, and that's Mary Tinker. The case is Tinker versus Des Moines Independent Community School District, 1969. You recognize, of course, the Vietnam War is raging at the time, and Mary Tinker, a very young student, in school at the time, she decides that she wants to protest the Vietnam War. And so she, among others, and that's one of her friends there, she puts together these black armbands that have the peace sign on them, all right? And she wears them, and she distributes them, and she has got a lot of people inside her school who are wearing the band. You know where this is going, right? The administration says, oh, no. We can't possibly have you do that. By doing that, you are disrupting the operation of our scholastic and academic purpose here. You're disrupting education, and therefore you're going to restrict you. We're going to take those bans off. And again, I suspect virtually all of you would recognize today that in clothing, some things can be disruptive, absolutely. This probably would look back on it today and say this is a pretty benign thing. And I suspect you all have probably sons, daughters, maybe grandchildren as well, who wear things like this on a regular basis with no problem at all because it does not disrupt the operation. But at the time, in 1969, again, different time in our nation's history, this was a big issue. And the question was, is Mary Tinker and her friends, do they have a First Amendment right as minors to do what she is doing? And in the end, the United States Supreme Court, 7-2, says yes, they support her. And they once again articulate this substantial disruption test. You can't stop, you can't censor young people, you can't censor students or punish them because of certainly what they're advocating for, unless, in fact, that advocacy somehow is so disruptive of the academic setting that you can identify that with particularity for a court. That's the material disruption, cannot substantially interfere with the appropriate discipline in school operations. That is intentionally by the Supreme Court in the Tinker case a very high standard. And that's the reason why up to this day, Tinker remains the key to freedom of expression for students. Again, public schools, obviously colleges, universities, a different layer, and a whole lot of other considerations there, but it remains a significant First Amendment case out there. You should know that in the wake of Tinker, the Supreme Court began to go in the opposite direction and began to impose more and more, support more and more restrictions on the capacity of students to speak out, including newspapers and other gatherings, even to formulate clubs. I'm not going to get into all that history, but along the way, for example, the Supreme Court in 1988 issued an opinion called Hazelwood. And it was among these cases in the wake of Tinker that began to go in the opposite direction. And specifically, the Supreme Court said that speech in a public setting can be restricted if, in fact, it is inconsistent with articulated educational goals. You might think, well, gee, isn't that specifically undermining what they said in Tinker? It underscores the fact that this trend goes in the opposite direction. And the reason why I raise that here, especially with respect to what's going on today, is that the issue has become a little bit more clouded, and the Supreme Court has issued a number of cases that variously support and then do not support the capacity of students to speak openly under the First Amendment. Another, perhaps the third one of the evening, something happened just today in this very issue, okay? So the Noblesville Students for Life, they are in a school district right outside of Indianapolis. It happens to be inside our circuit, which is the 7th Circuit, Wisconsin, Illinois, and Indiana. And what happens is that a student club called the Noblesville Students for Life, they wanted to post flyers in the school. They've got banners, somewhat like those that you see on the screen. That's a protest, obviously, in front of the Supreme Court, both with respect to right to life and right to abortion. A lot of controversy over that issue. And this particular group says, I would like to put these banners up in school that say, I reject abortion, defund Planned Parenthood, I am the pro-life generation. And because of various circumstances there, the school said that those particular signs are sufficiently evocative and may in fact disrupt the school operation, and the school says, no, we cannot permit you to post those. And as a result of that, she takes it into federal court. The federal court supports the school in saying on this, because of, again, a huge amount of evidentiary support for the school here, restricting displays as being disruptive of their educational purpose, goes up to the Supreme Court, at least, and then the 7th Circuit supports all of that in favor of the school restriction when it comes to this particular matter. Earlier today, the United States Supreme Court says we're not going to take that case. They decided not to review it further, which means that the 7th Circuit position remains in place. And note along the way that they find that the decision by the school under these circumstances, probably animated as well by the nature of the advocacy itself and the notion that by doing this you're going to disrupt the operation itself of the school. The First Amendment protections against government abridgment here do not apply, and the student in this particular case, she is unsuccessful in getting the administration to post those kinds of things. And again, it's a fascinating case. Again, many of you, I suspect, would probably find yourself on one side or another on the abortion issue, and also then, for the various reasons, the same reason, find yourself, well, gee, should those limitations be imposed upon her, upon others on the opposite side of this? But it underscores, again, the limitations on First Amendment rights, even for students, and the fact this continues to be an evolving issue. Supreme Court apparently satisfied with what our appeals court said, that there are limitations, and that student officials, school officials, can impose limitations on students. And then let's talk a little bit more here as we think through all the various phrases of the First Amendment about freedom of the press. And we're going to get back to this, as Kristen said in some remarks before we gathered here today. We're going to be talking about the media in one of our later classes. This is a bit of a teaser for that and a bit of anticipation of our future discussion. It is relevant because this continues to happen on a regular basis. The case that you probably all know very well, New York Times versus Sullivan. As you can tell, and you know this from our past discussions, I know you feel the same way. These cases come out of specific facts, and New York Times versus Sullivan is one of those. You've got a law enforcement person, and his name is J.B. Sullivan, and he is providing law enforcement. He maintains safety and security for some of the civil rights protesters in Montgomery, Alabama. He's basically the principal law enforcement officer there. And among other things, he makes arrests. This is during the course of the Civil Rights Movement. He arrests Martin Luther King Jr. on a number of occasions. He does other things during the course of his attempt to try to, in some ways, stop, but not impede completely the conduct of these civil rights movements, specifically in Montgomery. What happens, however, is that the New York Times gets it wrong when it comes to describing what he did. And in particular, they overstate the extent to which Sullivan is limiting the capacity of the protesters to protest. And a number of different areas, the reporting from the New York Times is simply inaccurate. Okay, it's wrong, and demonstrably so. We did not arrest Martin Luther King Jr. 7 times. We did not restrict access for various people to go in various places in and around the city. And so what happens is that the New York Times, however, issues, and you can see it historically, you can pull this up, as variously called an advertisement. It really is a report, kind of a special report, on the burdens that are being faced in Montgomery, Alabama by civil rights protesters. Turns out that some of the things in that report by the Times are inaccurate and demonstrably so. Sullivan turns around and he sues the Times, and he says, what you have done is you have defamed me. You have said things in the public domain that are not true. And I want you to have a judgment entered against you, a monetary judgment. You can't take it back. But you've damaged me, and for that reason, I'm going to seek a remedy against you. Lower courts, the Alabama courts in particular, the trial court, the state Supreme Court, they agree with Sullivan, and they say, yes, indeed. The New York Times has misstated what you did and did not do, and for that reason, we're going to enter a $500,000 judgment in your favor. Case, again, a whole lot more complicated in the way that I'm describing it right now, gets up to the Supreme Court. And the Supreme Court reverses that position and says that, yes, indeed, the New York Times got it wrong. They misstated some things about the operation of law enforcement in Montgomery, but the standard when it comes to, number one, public officials, which he is, and the media in particular is, you've got to be able to show actual malice. You've got to be able to show that the newspaper, the press sat down and said, I want to get this person. I'm going to create something knowing that it's wrong, purposely intending to harm them. The actual malice standard is what the Supreme Court issues and articulates in this major case, in the 1960s there. And so that's the articulated view of the Supreme Court in that time. Again, the fundamental notion here, to succeed in a challenge to press freedom, a plaintiff has to show that the defendant either knew that the statement was false or recklessly disregarded it when it might be otherwise so. A huge standard. And what is the big takeaway from that? Again, I know there's an awful lot of legal language in that and the entire articulation of the actual malice standard. The notion is that, again, he's the Chief Justice of the Supreme Court. His name is Earl Warren at the time. Again, 1960s, a time when First Amendment rights were routinely supported. He says the right of the media, the First Amendment, the press that James Madison talked about, is so important in America, so important that if you are a public figure, even if the media says something about you that's wrong, is not true, the only way that you can recover and push them back and be successful in your challenge is if you show that they actually intended to go after you. If they actually had malice in doing that, if they made a mistake, if they erred, that is not sufficient. And again, you might think, well, gee, that doesn't sound completely fair out there, but that's the standard, and it underscores the reason why the Supreme Court thinks the First Amendment, when it comes to press protections, is so important. I'll make this relevant, again, in a couple of different ways. You may or may not recall this, that on a number of occasions, actually two or three different trials and a number of dismissals of her cases. This is Sarah Palin, obviously at one point a candidate for the vice presidency. She's a former governor of Alaska. You know her well. And along the way, not too long ago, actually a number of years ago, the New York Times once again gets it wrong as to her. And they publish reporting about her campaign that ties her campaign to the attempted assassination of Gabby Giffords, okay? And when you read it today and you look at some of the visuals that the New York Times put out there, you can understand why Sarah Palin was understandably upset with what they did. And it turns out that the tie between her campaign, her advocacy for gun violence in America with respect to Gabby Giffords and others was simply unsupported. And the implication made by the New York Times was simply misleading and wrong, okay? And so she sues, the same kind of thing. And she says, yeah, I know, under New York Times versus Sullivan, I've got to show actual malice. And believe it or not, this case goes to trial on 2 occasions. 2 juries find that there is not a basis for awarding her judgment. They find that there is not actual malice in this case, even though the Supreme Court got this very incendiary thing about her and her campaign wrong. One of the editors of the New York Times takes the stand in one of these trials and looks at her and apologizes and says, we got it wrong. I am sorry. And even so, the instruction from the court under New York Times versus Sullivan is because you cannot prove actual malice, that someone sat down and said, we are going to put this together knowing that it's wrong, knowing that the tie between the Palin campaign and the attempted assassination of Gabby Giffords, it doesn't exist. Because that wasn't there, 2 juries come to the conclusion that there's no judgment. A court also dismisses it. What is the point of that? Again, in a world of perhaps perfect fairness, you would say, well, gee, was she affected by this very public report about her campaign? You bet she was. But the standard is so high to ensure that our press is free that you've got to show, once again, I've said it now 17 times, this very high level of intent. And the reason I bring it up tonight, and again, not a specific reference here, but you recall as well, another case he's brought a number of them against the media. Again, without being partisan at all, we know that the President of the United States of America has routinely sued a number of media outlets, and that includes CBS. You may, again, many of these out there, and we can make reference to them. One of the things that he alleged, recall this, is that while there was an interview of presidential candidate Kamala Harris, and specifically with respect to some of the things that she was saying about international matters, that CBS had purposely edited this interview. Remember this story? And as a result of that the president, in his campaign, at that time he was he was a public figure, but not a public official at the time, that he was harmed by what CBS had done. And he sought, again, huge damages against CBS for that violation of what he thought were his rights. Again, he's a public figure, and he alleges that the CBS had engaged in conduct that is not protected by the First Amendment. And when virtually everybody looked at, maybe not everyone, certainly his own lawyers felt differently, but when you look at that under these very high standards, and number one, you ask, gee, is that a basis for filing a lawsuit? The answer should come back for most people, and it was resoundingly dismissed as a frivolous lawsuit. The answer, once again, goes back to New York Times versus Sullivan. The only way the president could have succeeded in that case in which he alleged, again, that CBS had edited somehow this interview of Kamala Harris in such a way that would somehow affect him, maybe not even defame him, but kind of a reverse discrimination kind of approach to this, was if he was able to show that they actually sat down and did this for the specific intent of harming the president and doing this with actual malice. And even as I say this out loud, I hope that all of you are thinking, there's no case here at all, right? And what is the point of this in the end? In the end, when we were all looking at this and saying, New York Times versus Sullivan protects CBS. And certainly when it comes to editing, those of you who've been a part of any sort of journalism, when you speak to a journalist, whether it's a print journalist, certainly on the radio or television, you know that they're going to go back and edit your comments, hopefully not to re-describe them in a way that you did not intend. But if I sit down, you can well imagine, I'm going to speak for an hour and a half. It's going to end up on the news for 45 seconds.
I anticipate that will happen. And the only basis, once again, for me to attack that is if it turns out that they remove the word not from one of my sentences or say something that completely changes my intent. No basis for doing this. Why is it then that CBS News agreed in the end to pay the president $10 million, supposedly to rectify the damages that they had presented to him and given to him in this case? And it strikes me again today as one of those situations where we're sending the wrong messages about freedom of the press. And again, people, lawyers and others, press people who are a whole lot more intelligent than I am, look at this and say, New York Times versus Sullivan would have resulted, as it did in the Sarah Palin cases, with the outright dismissal of that kind of thing. The challenges that the president has made to other media, including an Iowa newspaper, you know them well, all around the nation, his threats to media generally, none of those approaches this high New York Times versus Sullivan standard. And yet, media more and more, not universally, more and more saying, yes, we're not going to fight this, we'll give you money. I would offer to you, again, without being too critical of my president, that kind of thing is not consistent with what the Supreme Court has said about the First Amendment when it comes to the media and press in particular. And then, as we come to the end of our time together, I simply wanted to spend a little bit of time in this setting, again, knowing we're going to go back and do a number of these issues, as we get together here on the 15th of June, to encourage you in the next couple of weeks, maybe 14 days or so, to be thinking about what the Supreme Court has been doing recently and what it has not been doing recently. The purpose of these classes, as Kristen and I said at the outset, is to talk with you about, yes, decisions of the Supreme Court, but also these general rules having to do with the First Amendment and rights. We're going to do more of that in the future. Next time, as I said, we're going to spend a lot of time talking about the relationships between the states and the federal government and do all the other things that are on the agenda coming up here. It is significant to me that as we meet here on the 15th of June, that the United States Supreme Court, as you well know, typically gets all of its major business done by the 4th of July. That is about 14 business days from right now, all right? And by my last count, which I did just before we gathered here tonight, Supreme Court has 23 more cases to issue on its docket. Out of about 67, they've issued about 2/3 of them, 23 more to issue when we gather here. Now, it may be that those of you who are viewing this particular video, maybe it will change by the time that you're consuming this. But as of right now, the message I would send to you is hold on, because in the next few days, look at the kinds of things that the Supreme Court is going to be issuing when it comes to decisions. Not clearly a lot of First Amendment or other cases involving freedom of expression, which we've talked about tonight, but look at the kinds of things that are still on the docket yet to be decided. We know about 14th Amendment and birthright citizenship. The president on his first day in office saying that the 14th Amendment does not provide for citizenship of everyone who is born here. In fact, he says if you are born of a mother, arguably of a father who is illegally here or here only temporarily, we do not have jurisdiction over you, and therefore invoking some of the language of the 14th Amendment, you are not a citizen. It appears that the Supreme Court in that case is not going to buy into what the president has said, is not going to overturn, frankly, well over 100 years of precedent. It's going to say, yes, indeed, the principle remains that if you're born here, you're a citizen. But that still remains to be resolved, and we're still waiting for that decision to come out. Look at some of the other things that are out there. There are 2 huge cases involving guns, one of them having to do with private carry, and another one having to do with the prohibitions on the sale, the use, the acquisition of guns. Huge two big cases under the Second Amendment, also obviously a part of the Supreme Court's docket. Transgender women in sports, that issue. Can states restrict transgender women from participating in women's sports? Another issue the Supreme Court is going to be deciding. I would offer to you that the second most important case, not eliminating or undermining in any way the significance of all these others, presidential powers. What kind of powers, authority does the president have to terminate people, leadership of the Federal Trade Commission, of the Federal Reserve,
independent agencies, independent of the White House. Does the president have the capacity to terminate people on those boards, on those agencies, because he doesn't like their policies? Or, as the Supreme Court said 100 years ago in a case called Humphrey's Executor, should the president stay far away from that? It appears that the Supreme Court may be split on those cases. We'll see that. Huge case involving presidential authority, and then a huge amount involving mail-in ballots and also campaign financing. Can states count mail-in ballots that are postmarked on Election Day but not received until afterwards? Many states have that. And what about campaign financing? Can political parties directly support and provide money to campaigns, individual candidates, restricting or reversing perhaps restrictions that have previously been in place? The last thing I will say about this is what you don't see up there, of course, is what I maintain is the most significant case they've already decided. We'll chat about it more during the course of future classes, and that is this case called Calais coming out of Louisiana. It's the Voting Rights Act. It's the Section 2 case that all but eliminated, as Elena Kagan said, the remaining capacity of the Voting Rights Act to address racial discrimination when it comes to voting in America. That's been decided. We'll chat about that down the road. But I underscore once again the significance of the time between now and the time that we get together to celebrate and acknowledge the 250th anniversary of our nation. Supreme Court is going to be doing a lot of things, presumably. There's a chance they may go beyond the 4th of July, but it's also highly likely that maybe beginning as soon as tomorrow, the days ahead, that we're going to have this onslaught of major cases that are going to be decided. And with that, I will simply tell you that we do have more classes coming up. As Kristen said at the outset, that's the schedule, focusing on all kinds of things that are important to our understanding of what's going on in America. And wanted to, again, thank you so much for this evening and for your engagement in our discussion. The first discussion about civil rights and civil liberties will continue this again in our next session on the 25th of June.